Justice and Associate Justices, good morning. Thomas Turok is here on behalf of Ami Perry in this matter. And I'm here challenging the appeals court application of the functional equivalent test that they used in this case to find that the expandable metal baton that Mr. Perry was found to have possessed was the equivalent of, or the functional equivalent of, a blackjack. The statute at issue here, Chapter 269, Section 10B, I believe is very specific, and one of the enumerated prohibited items is a blackjack. It was the trial testimony here that this item was not.
Excuse me, did they define what a blackjack was?
The statute itself does not. At trial, the Commonwealth's expert is found by the appeals court to be a police officer with 27 years of experience with both blackjacks and batons, unequivocally stated that this was not a blackjack.
Yeah, I understand. But he said it had the same kind of function. But I'm going back to the statute. The statute does not define blackjack.
The statute does not define blackjack. By applying this test, though, that the appeals court has used here, there's a number of defects and there's a number of problems, because the test is contrary to established law. It's contrary to the principles of strict statutory construction. It's a precedent that sets it's a bad rule of law. It's open to absurd and ridiculous conclusions that can come from applying that test, and it violates Mr. Perry's due process rights. Going through those, not only did the police officer testify that this was not a blackjack, both on cross and on direct, but the trial judge himself, I believe, recognized, and I have a quote there in my brief, that this was may not be, I think his words were, may not be among the enumerated weapons. He also recognized the principle of strict statutory construction, but yet he made this finding, which I think is contrary to that principle. Now, my brother will cite a California case, but I think that case has really no bearing upon this one because the statute is different. That defines a class of weapons. Here, in this case, and the California case is the Mercer case, here in this case we have a specifically enumerated weapon, which is the blackjack. And in fact, the Mercer case, there's a quote in here: the legislature did not prohibit the possession of a blackjack as such, or a billy as such, as it might have done, but instead, and very likely with the appreciation of the difficulties of nomenclature, forbid ownership of any weapon of that class. Now,
So I assume you're saying that the legislature could repair this problem by using language similar to what immediately follows the word blackjack, which is metallic knuckles or knuckles of any substance which could be put to the same use.
I think they could repair it by using, I think they use the word similar later in the statute, or use the word of a kind or of a class. But here, they haven't done that. And when they amended the statute, they didn't do it. And I think it was amended back in 1957 or somewhere around that time period.
So the basic theme is if the legislature wants to say something like a blackjack, it says something like a blackjack in the statute. If it wants to say it must be a blackjack per se, it says blackjack.
I think that's correct. And here we don't have a blackjack. We have what's been defined as an expandable metal baton. Now, under this ruling here, you have a situation where really any item with a weighted head, a flexible staff, and a handle or a grip, it could be the functional equivalent of a blackjack. Well, that defines a golf club with a graphite shaft. Under this holding, a golf club could be deemed to be a blackjack. I also, if you apply that functional equivalent test to other items, in my petition for further appellate review, I outlined that tobacco could be the functional equivalent of marijuana. It leads to absurd conclusions. Aspirin could be the functional equivalent of OxyContins because they're all painkillers and they share similar properties. So I think that as a principle of law, it is a bad precedent, and it flies in the face of strict statutory construction. I think this also, I think it's clear from...
May I ask you this? This is not directly on point, but I'm just curious. Would expandable baton qualify as a dangerous weapon?
I do not think it is a dangerous, you're asking a dangerous weapon per se. And I would say, no, it's not a dangerous weapon per se. I think that you can see the proposed testimony was outlined by the Assistant District DA of Mr. Perry's proposed expert, who would have testified that a big pen is more dangerous than the expandable baton at issue here, that it won't puncture the skin and that it would essentially hurt when it is used. But I don't think it would be a dangerous weapon per se. I don't think it could be defined in that manner.
Do I understand, Mr. Chilokis, that if you look through 269 Section 10, which has got a whole bunch of dangerous weapons, you cannot take this and fit it into any other category? It was blackjack or nothing?
I don't believe you can, no.
Okay. I mean, I just haven't gone through and matched up the description with everything.
And I think this is a problem that needs to be, if it needs to be addressed at all, addressed by the legislature. And I think that in the context of this case, Mr. Perry should have been found not guilty of the charge. I think his due process rights here have been violated because I don't think there is fair notice of what is prohibited. It's not an enumerated weapon. You have a Commonwealth expert who is saying that it's not the prohibited blackjack of which he is charged in the complaint. And I think that a reasonable person in his circumstances could not have imagined that this is a prohibited weapon. I don't think that due process requirements have been met and that notice is appropriate in this case. I think the fundamental problems with this functional equivalency test, because of these problems, this test can't be applied here. It would be an unwarranted expansion of long-standing precedent here that we have to strictly construe statutes to the meaning that's stated in there, that if there's any ambiguity in the statutes, that this should be, that ambiguity must be resolved in favor of the defendant. And under those principles here, I think that this conviction should properly and correctly be reversed.
Thank you, Mr. Chilokis.
Thank you. And I'll rest on the brief if there's anything further. Thank you.
Mr. Markov, good morning.
May it please the Court, Michael Markov on behalf of the Commonwealth. I would just like to address a few points that have been raised by my brother. The functional equivalency test doesn't come into play unless we're dealing with an object that is a weapon per se and has no other use. The proposed expert testimony that the defendant wanted to introduce was essentially that this weapon, while a weapon, did not inflict any more injury than other items might, and the example used was a big pen. That's irrelevant. The first question in looking at the functional equivalency test is this a weapon per se?
Well, why do you even get to functional equivalency if you look at the statute and you've got a lot of other opportunities maybe to get there, but with respect to blackjack, it doesn't have any suggestion that you could get to functional equivalency.
I agree. I think we go the other way. The functional equivalency test tells us whether or not this item we are dealing with is within the scope of those items that are enumerated or they're listed in the statute.
How can you say that, though? I mean, point me to the language.
Well, the language, unfortunately, the language comes out of the prior cases, the two appeals court cases that are cited.
No, in the statute.
The statute does not specifically say that. The statute simply lists a variety of items which are prohibited. Blackjack is listed, and there is no further qualification, classification, explanation. There's no definition of blackjack, for instance.
But it's not as if, as Justice Gans points out, it's not as if they don't know how to do that. I mean,
true, but the issue really, as for blackjack, is what exactly is this thing that's being prohibited? The statute doesn't define it, and as far as I've been able to tell, there is nothing anywhere in the general laws which defines blackjack. So you have to go outside the general laws to find out what we're talking about.
Why? Because we know what a blackjack is.
Well, a blackjack was, as I understand it, it was primarily a 19th century device that has in its original form is no longer in use because there are so many better alternatives. The purpose of the blackjack, as we laid out in the brief, is essentially it's a small weapon that can be easily concealed, but that extends out to greater than its length. But basically, you swing it, and it has some type of a weight at the end that.
Why wouldn't the legislature, as they did in other, with respect to other types of weapons, in this very statute say, or similar kind of weapon?
Well, I can't read the legislature's mind as to what they intended. I think that that an explanation is that a blackjack is by itself a class of weapons rather than a single device. I noted in our brief, for instance, that there were at least two different definitions that I found, one of which required that it be a lead device on it, the other didn't. So could the legislature have done that? Certainly. But they didn't, and so we're left with the language that they gave us, and the language simply says blackjack without telling us specifically what a blackjack is. And the question and the issue
I don't mean to interrupt you, but whatever definition of blackjack one comes up with, this article is not that, correct?
it is not a historical blackjack. It is not a blackjack that one would have found in 1850.
Well, you just say I found two definitions, and whatever definition, it's not that.
It does not match up with either of the classical definitions.
So there's nothing ambiguous about the statute. I mean, somebody may have constructed, and some things that can injure, and for which you think there's no purpose other than to injure. I don't know what those are, but they are. Presumably somebody's thinking of them. And if they're not outlawed by the statute, then it's not against the law to carry on a person or under his control, those things.
Okay.
I mean, the statute doesn't say anything that is capable of inflicting harm.
No, it does not. Again, all the statute says is here certain types of items are prohibited, but doesn't tell us precisely, at least in the case of a blackjack, what that is.
No, but you keep telling me that, but in fact it does tell us what it is. It's a blackjack, and this isn't a blackjack.
Well,
it looks like it tastes like it feels like it smells like it, I don't know, but it's not a blackjack.
Essentially that is correct. The witness at trial did say this was not a blackjack, although it had all the characteristics, both in function and in form, of a blackjack.
What do they call this thing?
I believe it's called an expandable wand.
Baton.
Baton, excuse me, expandable baton.
But baton isn't prohibited.
No, baton isn't. But we put in two pictures of this in the Commonwealth brief to show what this thing is. This thing, in its compact form, is a small cylinder. It expands to have a large protrusion coming out of it. There is no evidence that this thing has any use other than as a weapon. The officer who testified at trial said it was a weapon that was used like a blackjack. The defendant's expert was not going to contradict that. So there is no, in this case, this actually is a pure weapon. It has no other purpose. It's not like a knife. It's certainly not like a golf club. It cannot be used for anything other than combat. That's it.
If you go to a catalog of weapons, is there a page on expandable wands?
Well, there's not in the record of this case, but I can tell you that you actually can go on the internet and find expandable wands, and they are weapons.
And they're not blackjack. They're in a different page than blackjacks.
I don't know that you can get a blackjack, a traditional blackjack, because they're basically passé. They don't, in their original form, they're not used anymore because there's so many better alternatives. So I don't know the answer to that question, but I do know that although it isn't in the record, you can get an expandable wand as expandable baton as a weapon if you look for it. So, again, the Commonwealth's case is essentially based on the earlier appeals court cases, which did use the functional equivalency test, and specifically, again, I believe it was the Miller case, addressed the issue of what is a double-sided, what is a dirk knife. which again has a specific definition. And the appeals court went through a fairly long analysis of what makes what are the dirk-like qualities that make a knife a dirk knife. We had the same thing in the Commonwealth versus Commonwealth versus, I think it was Smith case, where the question was what makes a double-edged knife. And the item in Smith clearly wasn't a knife in the normal sense. It had no handle. It was a shank, manufactured by, in a prison to be used as a weapon. But it had enough similarities with the double-edged knife to fit under the definition provided in Section 10B. So those cases, I think, were the ones on which the current conviction is certainly appropriate. My brother raises the issue as to whether those cases essentially are incorrect. And I don't believe there really is any alternative to either having a statute which can be enforced or a statute which can't be. The idea that you can constantly amend the statute to keep coming up with new weapons that are slightly different than the one that came before it, I don't think it is.
No, you just have to add language about or similar or functionally, you could add or functionally equivalent.
Well, if you added that language, it really doesn't eliminate the complaint that this defendant is raising, which is that he didn't have fair notice of what it was that he was prohibited from using. And if you add that language, or similar, or functionally equivalent, if you don't read that as being implicit in the statute, it raises the same question. Is this device that he was in possession of functionally equivalent to a blackjack? You can always raise arguments, well, no, I didn't really think it was. It didn't have any leather on it, therefore it was different in this way, it was different in that way. So I don't believe amending the statute in that regard gets us out of the question. The real issue is, do devices that are functionally equivalent to the ones that are listed, is it fair to prohibit the usage of and the possession of those, and does that give fair notice to the people possessing them? So,
Isn't there a structural problem, though, that 26910B has essentially two parts?
Yes.
And aren't we in the first part, unfortunately,
Yes,
not
we
in
are.
the second? I mean,
Yes.
so there's no question
No.
we're in the first part. Once you get down to the second part, this could be a billy or other dangerous weapon other than those here in, right?
Yes, I believe the second part, though, requires something more than mere possession. So,
No, I understand
right,
that.
So that's why, right, if the, we concede that we are on the first half of the statute, not in the second
Sure.
half.
So isn't it reasonable to conclude that the legislature said, look, this is not, quote, active use, this is just possession, and we're going to tell you you can't have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If you get out and use these things, we're going to say, or the functional equivalent. Isn't that a reasonable interpretation?
No, because I believe the functional equivalent, the language that says we're banning things or similar is also included in the first half. So
Yeah, but with respect to a chain or a knuckle, it's always very specific. It's a knuckle or similar, chain or similar, knife or similar.
the second half of the statute is geared at prohibiting something closer to use, although it has a couple of other variations. So when an item is being used in a
Right.
certain way, the question as to what the person thought he was doing essentially goes away. We know what he thinks he's doing. It's the first half of the statute that I think poses the greater problem, but I would suggest that the earlier cases are in fact correct, and that the functional equivalency test does protect the rights of individuals from being subjected to unfair prosecution without notice of what they were prohibited from having, but at the same time gives the statute some application so that we do have a statute that prohibits the possession of items which are clearly weapons, are clearly dangerous, and have no other purpose. Thank you, Your Honor.
Thank you, Mr. Markgraf.
SJC-10453 in Ray Care and Protection.
Thank you.